Good afternoon, everyone, or I should say good morning for some people, and welcome to our presentation today, which is FINRA Rule 8210, From Trigger to Hearing and Beyond. My name is Angela Turiano. I am a principal at Bressler, Amory, and Ross in the New York office. I focus my practice on securities litigation and regulatory work, as well as some employment law. And with me today, if we go to the next slide, to introduce my esteemed panel, we have Joe Calabrese and Sean Coughlin, who are also principals in the New York office and also focus their practice on securities, litigation, and regulatory work. In addition, Sean, Joe, and I are all alumni of the Brooklyn District Attorney's Office, and we will try our best not to regale war stories from that time, which we have a hard time doing when we get together.
Will fail.
And we are also all former in-house counsel, so we'll be able to bring that perspective to this topic today. Sean and Joe are formerly of Morgan Stanley, and I used to be with Merrill Lynch, and prior to that, I was with Oppenheimer. And speaking of Oppenheimer, we have with us today our special guest star on the Bressler team, Adam Algaze. He is the managing director and head of regulatory affairs at Oppenheimer and Company, and we are very glad that he was able to join us today.
Thanks for inviting me.
So before we begin, I just want to give you guys an overview of what we're going to be talking about today with regard to FINRA Rule 8210. You can go to the next slide. So today we'll be discussing, obviously from the title, Rule 8210. We're going to talk a little bit about the background of the rule and the reach of the rule. Then we're going to talk about triggers to FINRA investigations, representation when you get a 8210 request, whether it's to the firm or to an individual, the best course of action with regard to representation and any conflicts of interest that might arise. The best practices in responding to an 8210 request with regard to documents and information. We're going to then move on to OTRs and talk about preparation and best practices at the actual OTR. Then we're going to discuss different outcomes after the on the records are completed, best practices with negotiating with FINRA. Then we're going to discuss the actual hearing itself and best practices there. And finally, just a little bit about the appeal process. And just before we actually begin the presentation, I just want to mention, if you have a question, be sure to put it in the Q&A function of that's on the lower part of the screen. This will enable us to keep track of who's asking questions, and we'll be able to best respond to those questions. In addition, we all want to get our CLE, so we'll be giving the first part of our sentence halfway through and the second part at the end. So I guess with that, we can get started. If we move to the next slide. So Rule 8210, the SEC in various decisions, and as we'll find out later in our program, the SEC is the second level of review for these decisions if these matters go to hearing. The SEC has said that the Rule 8210 is an essential cornerstone of FINRA's ability to police the securities markets and should be rigorously enforced. It is a rule that is taken very seriously. Failure to respond to an 8210 request, I should say repeated failure to respond, can result and has resulted in a permanent bar from the industry. So it is taken very seriously. Essentially, it enables FINRA in investigations and other matters to demand documents, information, or testimony from broker-dealers or employees. And we want to talk a little bit about the scope. And I think in doing so, I just wanted to refer everybody back to the actual rule, because I think when you do these things long enough, you always forget to go back and look at what the rule says. So if you look at FINRA 8210, FINRA Rule 8210, 8210A talks about the authority of FINRA staff. And it says, for the purpose of investigation, complaint, examination, or proceeding, so very broad right there, authorized by FINRA bylaws or rules, FINRA staff shall have the right to, Section 1 says, require a member, person associated with a member, or any other person subject to FINRA's jurisdiction to provide information orally, in writing, or electronically, and to testify at a location specified by FINRA staff with respect to any matter involved in the investigation, complaint, examination, or proceeding. In addition to that, subsection 2 says, FINRA shall also have the right to inspect and copy the books, records, and accounts of such member or person with respect to any matter involved in the investigation, complaint, examination, or proceeding that is in such members or person possession, custody, or control. And we're going to get back to those words in a little bit. So essentially, from reading the rule, you can see that it is very expansive in scope. It gives the right FINRA the right to inspect and copy virtually all books and records of member firms, including, and associated persons, including obviously electronic data and emails and Insta messages. And in addition, it also, once FINRA has that information, it has the right to turn it over to other regulators and other domestic and foreign entities. So it is expansive in scope. So that begs the question, is there a limit to who can be subject to it, what can be investigated, and what documents can be requested? And for that, I'm going to turn over to Joe. Joe, what do you say on that topic?
So I think you've covered pretty well that the rule is exceptionally broad. Policy behind that is very simple. The regulator doesn't want the people they regulate, member firms, ducking behind what we would normally call, I guess, technicalities. FINRA's view of this is very expansive. They want to be able to see everything almost in real time so they can get an understanding of what took place in any given investigation. So the limits actually are very small. We talk about who for a second. So Angela read you the rule. They talk about it's basically anyone outside of a ministerial person. So perhaps maybe someone below, perhaps a CSA, someone working in the branch. But the reality is, if you are an associated person or you're employed by an associated person or a member, you're part of that group. When we were prepping for this, I talked about when I worked back at Citi, I tried a case for Citi and the client was not happy with how it worked out. And although there wasn't an 8210 on that case, the client then brought another arbitration against Citi for defending it, odd as that sounds, and against me individually. And I was thrilled because I walked into my boss's office and said, this is great. They have no jurisdiction over me. Someone write them a letter and tell them I'm not going to respond. And then knowing a lot more than I did about this, he laughed and he goes, we're registered. We're an associated member, right? It was Citigroup at the time. You work for us, you're in. And that was the end of that. And I wound up being very much involved in that case, testifying and so on and so forth. So the who is very, very wide. The what, same thing. And anything related to the subject of the investigation is pretty much on the table. So there are very, very few carve-outs that get you out of that. And then what documents can be requested? I used to hear a lot from my own clients, well, we don't have that in our possession. No, you may not, but your employee might. So as Angela mentioned before, we talk about emails, which obviously are in the possession of most broker dealers and wirehouses and stuff. But I've been ordered to produce the personal phone records of the broker, whether he's with us or not. Sometimes we have to reach out to them. Sometimes we have to ask for their assistance. Text messages now. Text message is the new version of the old email, where you see brokers talking to their clients often, usually not with firm equipment like that. So again, there's a tremendous breadth as to what they can look for. But then, Angela, as I think we've talked about, that brings us then into privilege. So if it's all right with you, I'm going to touch on that for a couple of minutes.
Before you move on, Joe, I just wanted to point out that in 2013, actually, FINRA amended 8210, and they added the possession, custody, or control part of subsection 2. And essentially, in addition to what that clarified is that even if the member firm or associated person doesn't actually have the document, if they can ask for it, if they can demand it from a third party, then that is fair game and that should be responsive to the 8210 request. And I think that was probably always the case, but in 2013, they clarified that to make sure that you understand that I don't care if you don't have it. If there's a third party that has it and you can ask for it, then that's responsive. So it just confirms what you said, that it really is expansive. I just wanted to point out the 2013 amendment.
Yeah, I think as electronic communication gets broader and broader and broader, you're going to see more work in that field. Like I said, it's text messages today. Any other communications within applications on people's phones, that's going to be the next step. So I think what FINRA has to do is stay ahead of that technology curve and keep up with what they can ask for, because we know now, as we've learned, people avoid emails by texting. Well, obviously FINRA is smarter than that.
And they avoid texting by using WhatsApp and other type of messaging apps.
Right. So I guess the one thing that might be exempt are privileged documents, which brings us to our next slide.
It does. All right, so let's talk about privilege for a second. We just recently did an ethics and a privilege in mediation webinar. And it's one of those things that you may not think about at first, but it's always something, and that's why we put it at the top of the deck, because a lot of people get that feeling that if they're talking to a regulator, the rules are different. And the reality is that's not true at all. I was talking to a colleague of mine about this as we were researching, putting this together. And I said, so what are your thoughts about regulators and privilege and how do you handle that? And the answer I got was perfect for this. And he said to me, you always have to remember that privilege is sacrosanct. Where it's easy for us as people representing our clients to say to an adversary, no, that's privilege and I'm not turning it over. But people sometimes are not as willing to be that forceful when it comes to a regulator. What you have to remember is this, whether we have it on the slide, it says FINRA, no regulator's authority overcomes privilege, period. And the penalties for waiving privilege, either intentionally or inadvertently, as you all know, are significant. And so you have to be very, very careful of that. And I would expect that those of you with a lot more experience would say, well, we know that already. But I think what you have to look to is in law firms, your younger associates, or in-house, some of your newer people who aren't used to this, that when you, just because you're talking to a regulator, it doesn't make a difference. Privilege is still privilege, and you have to zealously guard that. Certainly within the bounds of being reasonable, but I think what some people find is when they try to be reasonable with a regulator, they try to find workarounds and ways around that, and that gives them some comfort. And you have to be very, very careful about that. I spoke to an in-house colleague not too long ago about this, again, prepping for this. And their response was, well, we know the outside counsel folks tend to be a little stronger about that, tend to take a harder line, whereas we're a little more casual with it. And I'm thinking to myself, that can't be the case. That whether you're in or out makes no difference whatsoever. And whether it's a regulator or an adversary, honestly, when it comes to privilege, should make no difference whatsoever. So the question is, you still have an obligation to cooperate. That, start there. Privilege is sacrosanct, but you still have an obligation to cooperate. Where is that middle ground? Well, the first thing is, what kind of documents are the regulators looking for? And I think we all know the answer to this question, as we just started talking about. Emails, can be the holy grail of any case, right? Of any investigation, because people still, and it surprises me, write emails like they don't think anybody else is going to read them someday. In addition, I think more commonly with the rise of internal investigations and most firms doing those in-house, interview notes. Firms that run their own internal investigations, or at least their level 1 internal investigations, are going to have the notes of their attorneys who do that. That's why a lot of firms with internal investigations have attorneys running them. So that preserves the privilege. Or have an attorney sitting in on the meeting. That preserves the privilege. Regulators, for obvious reasons, want to see those notes. They want to see what the first thing their subject said about something. They don't want third generation of what the subject has to be. They want first generation. So the question is, what do you do when they come to you and they ask you for this type of stuff? I have found, and I think most of my colleagues have found, and I'm sure Adam can help us with this, is that under most circumstances, and I find this generally too, FINRA is going to accept. We wrote a privilege objection. I think maybe objection on the slide is too strong a word. FINRA generally is very acceptance of our explaining that certain documents are privileged. And a lot of times, if you say that to them, that's where it ends. And there doesn't really require a whole lot more. They'll respect the fact that you're being honest with them, that you have a good rapport with them, that you understand you have an obligation to cooperate. And sometimes when you say it's privileged, I would say probably, to be fair, 8 or 9 times out of 10, that's enough for them. But then there are the times when they're, yes.
Can I interrupt? I do think,
yeah, of course,
you need to turn around though and look at the materials to make sure they truly are privileged, that, the attorney is really actively engaged in doing an investigation, in providing legal advice there. Because we've seen in the past often, there can be business people talking with each other and a lawyer's name is on there, but the lawyer's got no role. And I think that if you hide behind that too often, you're going to get yourself in trouble with regulators. And so it takes time to go through the materials to make sure that legal advice is really being offered here, right? And
I think Sean makes a great point there. I think that's true. I think people see an attorney on an email and they just automatically label it privileged. And I think you have to go do a little further review than just, attorney name, privilege. I think that's 100% correct.
Sorry about interrupting, Joe.
No, it's a good point, because what I find too is any email that I get from either the business side or a lot of times from the business side, they'll slap the word privilege across the top of it. Somebody just mentioned in the QA that if I ask a broker for a document, like a new account statement or something like that, new account document, they write privilege across the top, right? You have to be able to distinguish between advice and just communication where you're CC'd. If you're merely CC'd, obviously, if you start going really broad and stuff like that, absolutely true, which is why the reviews that you have to do for this are time consuming and painful, because you really have to literally read every email. You have to look at the context of it. And you also have to look at whether or not it really does fit within those boundaries of privilege. Where there might be some disconnect, what are some of the compromises? FINRA may seek a privilege log, which I know, Sean, actually you're working on now, right? You want to talk about that for a second? Tell us how that's going.
Well, we just finished it up, but you've got to make sure you find out exactly the format they want that log. And frankly, what I thought initially would take me 3 or 4 hours wound up taking much longer because of, the desire to make sure that my representations to the regulators were accurate about that log, to make sure that every document that we had previously withheld were properly withheld and the reasons why.
So someone, I'm sorry, Joe, someone just pointed out that given the increased experience and expertise of enforcement staff, FINRA enforcement teams are now almost always, in my experience, asking for logs and less frequently pushing back on claims. Has that been your experience? And I would like Adam to maybe chime in on that one.
No, I've actually very rarely been asked for a log. If you develop a good enough relationship with FINRA and you indicate something's privileged, if I start claiming, 17,000 emails and documents of privilege, I imagine that might be an issue. But, it's about the negotiation, talking about it in the beginning. Here's what we're going to do for email searches. Here's the screens we're going to use. I've identified these as potentially privileged, and then letting them know, at the end of the day, we have, 75, 80 emails that we believe are privileged. And rarely I've actually been asked for a privilege log from FINRA. SEC is a different story. They frequently ask for the privilege log, but FINRA, not so much. And I wanted to just echo what Joe was saying, and Sean, with regard to the internal investigations and interview notes, and we obviously do, a decent amount of that here, is what I find is helpful, is because, look, I understand FINRA has a job to do. They need to get to the bottom of whatever, led to a termination or a disciplinary action because of an internal investigation. I find it helpful to say, look, exactly what you said, Joe, is we're not going to mean interview notes. We're not going to mean internal investigation notes, because those are all privileged. However, I will draft for you a summary of the meeting. I will tell you, it occurred on this date, and this is what we discussed, and this is what the firm's findings were, while not going through, a play-by-play of the 17 pages of notes I took. And FINRA appreciates that, right? So again, not to jump ahead to you, but like what you said, seek a compromise when you can.
And I think we've probably all had that type of experience where I think sometimes it works better when you come up with that idea. Listen, I can't do this, but here's what I can do. Like, don't wait for somebody to come back to you with, well, here are the alternatives we're willing to accept. Be proactive. Again, coming back to the fact that you have an obligation to cooperate, be proactive with what you suggest. So on a slide here, we talk about no waiver letters. I've had that suggested to me a number of times over the years. Not very comfortable with it at all, because third parties, other litigants future down the road, are going to argue that they aren't subject to that. And that once you've let that information out, the fact that you and FINRA have that agreement doesn't affect them. And I'm not suggesting that's an argument that's going to work, but it's an argument you don't want to have. So if you are proactive with what you offer, like Adam says, and Sean has said, that probably makes life a little bit easier. Sometimes you have to remember, though, you don't want to alienate the examiner. They're just doing their job. And talking to an examiner about what they want, even if you can't give it to them, it really is not an invitation to be adversarial. You have to be careful with that. You can be adversarial with people on the other side of the table when you're litigating with them, to show them that you're going to push and you're going to fight for your client. Regulators are not those people. Sometimes you'll probably figure out the degree of pushback that you get from an examiner, depending on how senior they are, can actually be coming from their supervisor. So, try to mine that a little bit, try to find new ways to do things. And if you can compromise, you can. And I think all of us on this panel, and most of you listening to us, can find ways to do that. So we're just asking you to keep it in the back of your mind. We've got something from in the chat that says there's no such thing as a selective waiver. Fair enough. That creates a minefield for a BD when asked to provide information that was collected as a source of internal investigation. All true. Coming back to, you have to be very careful with what you're doing.
Okay, I think we can move on to the next slide,
Sure. There you go.
which is FINRA investigation triggers. So we just want to know here, what is it that triggers the investigation, complaint, examination, or proceeding that the 8210 is being issued for? And for that, we're going to turn to Adam.
Sure. Thanks, Angela. So, these 4 items that we've listed, I want to kind of go through them and explain, how each of them, could ultimately lead to an investigation, and maybe talk a little bit about, how you can mitigate it at the early onset. So, with regard to the surveillance unit, this is oftentimes just based on reports that you provide to FINRA. And, for those of us who've been in-house for a long time, there's numerous reports. One of the biggest ones that, lead to requests for information that then turn into investigations is Blue Sheet, and Blue Sheet is Blue Sheet, right? You have to provide it on, we probably provide hundreds a day. And if there's a question, they come back to us. The only thing I'd say about the surveillance unit is not much you can do because these reports required, but what you can do to avoid an investigation relating to how well your surveillance systems work is to make sure you regularly test it, right? I've been involved in more than a couple of issues where it's about the fact that our systems aren't working as they should. And they often find that out when they get reports from us that, just don't have the right information. What comes to mind is many firms have been involved in it is, LOPR reporting cases. They take the information very seriously. They look at everything from the address as they're looking for an in-concert option report type of, violations or trading there. So you want to be very, very careful with the surveillance unit in terms of making sure your systems are working right. And when you receive the request, giving them as fast as possible. You get to the examination unit. Now, see, this is a whole different ballgame, right? So, FINRA comes in on a regular basis, as it says, for on-site reviews. More frequently, I see it for cycle exams, which, last anywhere from 3 to 6 months, depending on the examiner. And I think there's been a misconception. I've seen it, I've worked in 3 in-house firms in my career. And I've seen it range from, having a very senior person in charge of that unit. And then I've seen it with, sometimes staff with paralegals and compliance who provide documents. And during an examination, requests come in fast. You could receive up to 50 a day in the beginning. And it continues that way for several months, multiple interviews and whatnot. So while they are collecting documents, it's your obligation to try to find a way to explain the documents you're providing, right? So if you're seeing an issue when you're looking through those documents, whether it be, a policy violation, some type of, follow up on a certain type of custom complaint, that's usually when I get involved. Well, I have a team that works on these types of things. They call me and they let me know, like, look, this looks problematic, because you want to get ahead of it. So if let's take a policy violation, I give you a document and I see there's 2 different violations of policy from the firm in this request that we were providing to you, I'm going to go do a check and see if it's happened, 100 times, 200 times, or if I can identify it and say, look, this is a limited circumstance, because you provide that information to FINRA early on. When they start writing the exam report, they're not going to do a referral to an enforcement or another division to say, oh, they have a major problem here. So you want to get in front of it. You want to have a good relationship with your examiners. You want to be able to advocate, and advocation is really what we're doing here, to say, here's what the issue is, here's how we're resolving it. And oftentimes I find if you can do that, you will probably likely avoid an investigation. If you have a significant issue, again, coming forward early on, letting them know, and in the course of the exam, trying to resolve it and show them what you did, it's going to make your report look better. And frequently that'll lead to, no need for a further investigation. And we get to the DRP filings, which I think is where about 70 to 80% of our requests come in from FINRA. It's relating to the custom complaints and determination that we file on the DRP. Again, this is another example of what you can do to avoid additional work. So, an example I'll use is if I terminate someone because, let's say, extreme tardiness, me writing on their U5, terminated for violation of firm policy, that is going to do nothing to stop me from getting an 8210 request following up, right? I've given them no information. So all I've done is said, okay, great. Because I want to keep my job forever and ever, and I want to get requests, I'm going to just give the vaguest, I'm going to give the vaguest response. So, we as a firm, look at all the DRP filings before they go out, and someone more senior reviews them to ensure they're right. But in that instance, if you simply write, fire for firm policy, not customer related, no customer harm, something like that, relating to, personal conduct, my experience is FINRA is really not that interested in the personal conduct type things, right? Depending on, as long as you're not harming a customer or you're not doing something so egregious. So I always try to give, especially on terminations, as much color as I can, so I can avoid, having at least an 8210 come in with 700 questions that ultimately they say, oh, why don't you just tell us? It would have saved you a whole bunch of time. As far as goes, yeah.
I'm sorry, Adam. I feel like in that regard, I feel like sometimes the comment section where the financial advisor puts something in the comment section can cause a minefield of issues. Would you agree with that?
Huge minefield, so look, I advocate for the optional comments because, obviously, customer complaints, especially, right? It doesn't matter if it's true or if it's false. If someone writes today and says, my broker stole, $1 million from me, and then I speak to the financial advisor and he says, I've never even met this customer. I said, well, unfortunately, it's still going on U4 because those are the rules that we have to do. There I find an optional comment saying, I've never seen this person and she's, currently committed to a psychiatric hospital. I think that's going to be somewhat helpful. Unfortunately, though, the optional comments have now, I find people put things in optional comments or ask their firm to do it and say, can you write this? And it's either, defamatory in some ways, doesn't have a good look, or sometimes it just may not be accurate. And FINRA reads the optional comments and they follow up when they read an optional comment and someone writes something that just can't possibly be sent. They're going to open an investigation. And my guess would be is it's now about ethics as well, right? And FINRA has very strong concerns about the ethical conduct of its advisors. So yes, Angela, I 100% agree on that.
Before we move on, there's a question. We've recently been told that any arbitration filed triggers a request. Have you heard that? Like any arbitration filed? I have not heard that.
That is not my experience because I think frequently they do, but I think it oftentimes has to do with what the arbitration's about. If someone, and I think it's the amount, if someone files an unauthorized trading request and the damages are $455, I don't see a request coming in. But when they see an amount over $100,000 and several years of unauthorized trading, but they do read all of them. I wouldn't say everyone, but I'd say you have a 50-50 chance if there's an arbitration, you're going to get a request. And depending on how severe it is, how long it went on for, and are you dealing with a senior citizen? Those types of things are going to be immediate red flags to FINRA. But I wouldn't say everyone, but definitely about a 50-50. So, again, like I said, with the customer complaints, you want to give a good color of what's going on. You want to be able to explain what the firm, the firm's reviewing this, make sure you update it accordingly. Those can save you some trouble, again, from getting an 8210 request. I think, again, on tips and referrals, we, FINRA and both the SEC have sites that you can go to make a complaint. There's nothing I can do about it after they do it. But, frequently I hear from customers, we deny a complaint for whatever reason, probably because it's, not accurate, or we don't believe it something that we should be, fixing in any way. And they say, well, we're going to go to FINRA to go to SEC. My experience is they come to me and they say, we received this complaint. What do you say? And I give them a copy of the denial letter. I say, here's what happened. Here's why we did this. And frequently they go back to the customer and say, well, this is what the firm's position is. And, you do have an obligation, you do have a choice to arbitrate if you'd like, but, our review doesn't have this. Sometimes I've seen tips being delivered to, FINRA and or the SEC that claim some type of, unethical behavior or, either by a firm or one of its registered representatives. FINRA is going to investigate. And again, it's more helpful when I'm aware of it. And every now and then I get one that I've never heard of, and that takes some time. But, all of these, every one of them, it's all about, when you get the initial request, maybe it's going to become an 8210 right away. Maybe it's just an initial request saying, can you explain more about this? It could be in an email. The more you can give them while answering their questions, it just saves you so much more trouble when you later on say, okay, I only answered the question with a yes or a no, as lightly as I could, because the next one is, a 15-20 page response that you have to put in.
So it sounds like getting to the forefront of the issues and being as forthcoming as possible is the key to avoid further investigation. And this is why you're such a valued employee at Oppenheimer, Adam, clearly. So we should move on to the next slide because we're getting to 30 minutes in. And on that note, we'll move on to the next slide. But I just want to announce that the first part of the code is FINRA. So FINRA is the first part of the code. So now we're going to talk about representation of once you get an 8210 request, whether it's against the firm or the individual, representation and what type of representation you should choose. I can't imagine any situation where you wouldn't choose outside counsel and you wouldn't choose Bressler, but maybe Sean can tell me otherwise.
Well, I'm not going to tell you otherwise about that. But I think you really need to be very mindful when you're looking at what the request is and what the scope is and what's being asked. You know, who are you really representing? Are you representing the firm? Are you really representing the agent, the registered person? Because the allegations are related to a financial advisor or team of financial advisors. And is it a situation where you need to turn around and advise your client to get them separate counsel? Because if there are allegations that are brought against, you know, XYZ brokerage firm, and they're related to unauthorized trading, and as you do your investigation and your scope, one, you find that there was indeed unauthorized trading going on, and the financial advisor can't justify, you know, the phone records don't match up with the trades, you know, you're going to have to turn around and advise them that they need to be represented by several counsel because your interests have diverged, right? You're now in a situation where you've got to respond to FINRA about the lack of supervision, if you will, about what occurred, and the individual's got to turn around and justify why they had belief to make those trades. I think whenever you're dealing with representation, you've got to just go to your gut, right? You know, if your gut is telling you there is a difference in a conflict that exists between the firm and the individual, your gut is almost always right. If it doesn't pass a smell test, you've got to advise the clients, both the individual and the firm, that separate counsel is needed. And then hopefully you're going to find counsel for that individual so you can work together. Because while there are still differences in terms of, you know, your ethical obligations to the client, if you're now setting up a conflict with that individual, you're not doing the individual any service, and you're certainly not doing your client any service. So while, you know, things can break down and you need separate counsel, you've got to be mindful of what the true issues are and how you can put together information for the regulators that explains what happened, and then you work through the processes of coming up with a resolution regulators can accept.
I think that's true what you say, Sean. I think if you're questioning if there's a conflict, oftentimes that means there is a conflict. Right, exactly.
You know,
I don't know if any other of the panelists would like to comment on the conflict of interest portion before we move on, or if you have anything else to add, Sean. Go ahead, Adam.
I think the only hard part, you know, and this is from the in-house perspective, you know, because oftentimes when Bressler comes in, you know, frequently to help when I feel like there is a conflict, or sometimes it's just a matter of I can't provide the representation you need because of subject matter and or, you know, my own current workload. But, you know, you start off with, you know, all the right questions, and we take it very seriously, especially as an in-house counsel who might be representing both the firm and, you know, one of our employees. And then, you know, as it goes on, investigation, you start coming aware of things that are saying, oh, you know, this is not exactly what I was told in the beginning. This is not exactly how I expected to see, or just saying like they don't agree with something, you know, that the firm is, you know, believes this should be the position, and they say, I don't believe it's position. You know, you have to be conscious of that, right? You can't as an attorney representing a firm, an individual say, no, that's the way you're going to do it because, you know, we're the employer and this is how we want to do it. At that point, you know, I've had instances like that, you know, halfway through an investigation or halfway through some type of matter where I've said, you know, at this point, not because I think you're wrong and that's actually happened. I said, that's your position and you should be entitled to it. But at this point, we need to separate because I cannot do both. And I'm sure if you're representing both the firm and an individual, you have the same issues that come up.
And that's why you need to have, you know, a representation letter that clearly lays that out to the individuals who are involved from the get-go. So there really isn't a surprise and you can continue to represent the firm.
Absolutely. The
I
letter
think
is
that-
definitely of the most import. Yep.
I think that experience is probably more common in the in-house setting. The person is generally your employee. And I can tell you there's a major difference between delineating who the client is when you're in-house as to when you're at a law firm. That delineation at a law firm is very, very clear. In-house, especially if you start an investigation where you almost become, the person on the side of the broker that you're talking about. You're talking to them every day. You're answering their questions.
Yeah.
You develop almost a certain amount of allegiance, and you have to remember that you have to separate yourself. Much like Adam, I remember being involved in one unauthorized trading investigation where at the outset, it looked, maybe a little time and price, perhaps, on a really good day. And then the broker took a week off and went on vacation. And while he was away, we did more due diligence. And what we found is that he was trading from the other side of the world by logging in when he couldn't be talking to his client. And so when we had already set up the OTR for him. And I had to call FINRA back and said, we're not representing him anymore. And they said, why? I'm like, you'll have to discuss that with him.
Right.
You
Right,
got
and I think
you got to be really careful about that.
You really have to be careful, and you really have to explain to your client, the representation, and if the conflict arises, you have to withdraw. And you happen to be representing two individuals with regard to the same investigation. Make it clear to those individuals that right now we're all on the same page, but should a conflict arise, then we have to separate. And this all has to be set up front to make sure they understand what a conflict of interest is, whether one exists, and if one should arise, what will be the consequences of that. And that's very important.
You know what always surprises me? When we would send out that joint rep letter, which is very thick, it covers every base.
Mm-hmm.
I remember sitting with colleagues saying, I'd never sign anything like this.
Well,
And you send it out and you get it back in 10 seconds.
Okay, well, we need to go on. We could continue talking about this forever, but I think we probably need to move to the next slide at this point in time because we haven't even gotten to responding to the 8210.
There you go.
Which is our next topic and which we're throwing to Adam.
Sure.
I think.
So, and I see we're going a nice speed here. So here's what I would say is the first two things you see on here is the negotiating the scope and the considered rolling productions, right? So this is what you want to set right at the very beginning, right? So I think there's earlier I was talking about, people, just treating themselves as document collectors. And I still see it to this day when a request comes in from any regulator and, stick with FINRA for this purposes, and they ask for, let's just start off with, email, as Joe said, the holy grail, right? And they say, we want every email from Adam Algaze and Angelo Toriano from 2008 to 2016, and that's it. I've seen firms and I've seen people at firms run and say, okay, we got to get this all together and let's get a vendor lined up and everything. And, and it's relating to one single client. These requests sometimes do come in, broadly, depending on who you're working with at FINRA. That's how it works. It is nothing wrong with calling up a FINRA and saying, hey, look, they don't want to receive 10 million emails either, right? Say, look, you're looking for, Sean Coughlin, his client, you're looking for it. He was only a client for the last 4 years. Why don't we limit it to 4 years using any email address he had and any mention of the security? They always say yes. The one thing I find say when they don't say yes is I always commit to, if you don't think that's enough after you receive it, we will provide more. We could talk about it, but again, like we're talking about, it's about providing them options, right? And as long as they don't feel like they're entering into an agreement and that's what you agreed to, and that's what we're doing, even though under the 8210 rule, they don't have to, they're willing to work with you. Next thing is the overpromising, right? So why I wrote consider rolling productions is because it's very easy to say, sure, I'll have this to you in 2 weeks. And then you call them in 2 weeks and say, I need an extension. And then, well, I'm sure we'll have it by the end of the week. And you're calling them up and like, we need another extension. And, extensions are part of the business. It's just, 2 weeks is oftentimes not enough to do most of the requests that come in. However, if you say, why don't I provide this by here and this by here, and I've already spoken to our technology group and they can get this, it's probably going to take 4 weeks. If you set those expectations right at the beginning, you're not going to end up in a bad place with the investigator or enforcement person you're working with. And I think that is key. You need to build those good relationships early on because those are going to lead to the good outcomes.
And that enforcement person, Adam, is working for somebody else, right? And so they're answering to somebody else and they need to turn around and say, this is what's going on with my case.
Absolutely, 100%. And, I think people should just not be afraid to negotiate. And I still see, this tendency, no, just do whatever they want to do. And, you're opening up, a can of worms with yourself, the cost of doing it. And my experience is FINRA almost always negotiates with you, especially when they send a request, as long as you can explain why, not just, I don't want to. So, and the written statement request, this kind of talks a little bit about, again, the conflict, right? So if they ask for a written statement from an employee, and maybe the employee is not involved in, the actual substance of the investigation, but they want a written statement, again, first think, can I represent them with regard to that written statement? And I think the big thing here is again, similar to what I was saying earlier, sometimes you want to give a little more, right? Like you have an option here to write a written statement and answer all the questions that they want and answer them in the best possible light that you can put yourself in, explain what happened. If it's relating to something that you did wrong, I often see those when, someone gets suspended from the firm for 2 weeks or whatever it is, some type of disciplinary action. I'm like, acknowledge it, acknowledge what's going on, tell them how it happened, what happened, but don't, FINRA does not want to read a 5-page sob story. I had a man who wrote all about his divorce for three pages, and that's why he was in a bad place. I mean, FINRA, is willing to hear that you had some personal circumstances going on, but you want to be able to explain everything you can in that written statement, so you don't continue to get request after request after request. And I tell people all the time is, if you don't take it right at the beginning, then it's just follow up after follow up after follow up. And again, something that can be addressed literally in the first time you get a written statement request.
Adam, can I ask you a question? What's your experience where an arbitration is involved, where they ask for a statement while you're still in the middle of everything, and people will often say, have the broker sign a statement that says, I adopt the answer?
Yeah, so, look, adopting the answer, I'm sure, is very, very common. And if they're asking for it in the middle of arbitration, that's likely what we'll do. They also oftentimes say, as soon as an arbitration comes in, they start asking for a firm response.
Right.
It's a good question. I mean, the arbitration was filed yesterday, and then in 4 days, I received, we want a firm response to the allegations here. And again, I find FINRA to be very reasonable. I said, look, our answer is due in 5 weeks or 6 weeks. At that time, I'll be able to give you a firm response, but I literally can't give a firm response to something that just was filed 4 days ago, because we haven't had a chance to determine as a firm how we're going to deal with it. And so the answer is always key. And, with regard to the answer, again, if the FA is not named, we may put in some additional information to give the FA, the representation he needs that may not be covered in the answer, but, adopting the answer is perfectly fine. And FINRA seems, well-versed in that. As a matter of fact, oftentimes lately, I've just been asked for the answer and nothing more.
So I think the key here is reasonable and cooperative. We'll get you a long way with FINRA. So with that, we'll move on to our next slide, which is the actual on the record after the written 8210 notice is issued, and FINRA proceeds with an on the record. So with that, we're going to go to Sean about how to best prep for an OTR.
So I think you've got to look at two things. One, I think it's very important to have some conversations with FINRA beforehand, so you can really focus in on what they're looking for, what their concerns are about the case. And when you have those conversations, some people might push back and say, well, why do you want to know? Well, I think the reason why you want to know is because you want to make sure that you can present and have the information available to answer the questions. And then with your witnesses, the most important thing, and whether it's OTR or litigation, have they seen the documents? Nothing is worse than having a witness sit in front of, a regulator and look at a statement and not be able to explain what's going on, because they haven't really looked at that. Nothing is worse than that. So I think you really need to make sure that you put in front of your witness every single document that you expect or that you believe might be shown to them beforehand. And you need to also—
To that point, Sean, that highlights the importance of narrowing down the scope of the production, because if your production is so huge. So yeah, I'm sorry, go ahead.
It all flows together. And then the other thing too is you've got to make sure the witnesses realize that in many ways, when they're out there, right, they're going to be on an island, because in an OTR, it's not litigation. You can't stand up and object about the form of the question. You can at the hearing in my experience, you can, if you see a regulator trying to go off course because they don't understand what the documents mean, you can help educate them about what it means. But hopefully you're dealing with experienced FINRA counsel and they understand what things mean. But you've got to make sure people understand going into it that you're not going to be objecting and being an advocate for them there. You're going to be, so that's why it's so important to make sure your witnesses understand what's being put in front of them. And I think it's also important to teach people, or to make sure to remind people, that if they come across like they don't remember, you know, their credibility is an issue, okay? And I think you've got to go to, what would a reasonable person remember? Now, it might well be you're dealing with an older financial advisor who's starting to have some cognitive issues. And if that's the case, I think it's important to make sure that FINRA understands that as well. You know, oftentimes we're dealing with older financial advisors who are being asked about questions, you know, about things that occurred 3 years ago, but they're now 76 years old or 78 years old, and they're not the person they were when they were 74. So those are considerations that I think you need to deal with going into the case.
And Sean, I was going to say is, you know, while I agree with you 100% on I don't remember on things that, you know, you likely should, I always tell witnesses, you know, I don't know is a fine answer.
That's a different answer though. Yep.
Because, you know, is the last thing you want to do is start speculating. And I think human nature allows us to, and someone asks a question, but if I don't know, we'll have to get back to you on that. And that's our job. But I don't remember, agree with you. I don't know, I think is a fine answer.
I don't know works unless it goes back to that gut check, right? Because if you hear the person say they don't know and you think they're lying about it, it's something, and that's why you prep people beforehand, right? Because that doesn't always work as an answer. But more importantly, having people get up there and start guessing, or because they're on the stand, they think they should know something, that is just terrible. And you know, we've all seen people get up there and they start to guess about one thing, and then later on their credibility is called into question, and that really hurts the case.
Okay, we could probably keep talking about this topic, but I think we probably need to move on due to time. So now we're at the actual OTR, and you can't really object to much at an OTR with the exception of privilege, questions that are seeking privilege, but there are times when it is appropriate to interject. So, and I think Sean kind of touched on that a little bit with our last slide, but when is it appropriate to interject at an OTR? And Joe, we'll start with you on that one.
I think there are two junctures. One is, and Sean's already talked about it, to facilitate what's going on. Every examiner is not going to understand documents, or at least the way that you might understand those documents. Every examiner may not understand the context of the way a broker is answering a question. Your broker may be answering the question the wrong way because they need a little bit of guidance too. And so being able to facilitate is very important. The question becomes how much facilitation the examiner wants. And so you're really going to have to understand who that person across the way is before you start doing that. But I've actually been in situations where if you come in as what looks like someone who's a friendly person there to help, and don't start talking right away, and appreciate the fact that you have to be quiet, and then saying, maybe I can help you with this, I found that works. You know, a little bit of sugar works a little bit. And I found examiners appreciate the fact that we can facilitate, because honestly, we know a lot more about what's going on in the case than they're going to, simply because we're that deep. The other time is when there's a mistake made on the record. So what you don't want to have happen is a lot of examiners are not trial lawyers. Their questions are not particularly precise. And then what happens is and brokers may not be smart enough, no matter how well you've prepped them, to correct an examiner who asks a question the wrong way. And now you're developing a record that is incorrect. When I was at Citi and we moved over to Morgan Stanley, there was a lot of reasonable confusion there among all of us as to what entity was in charge when something happened. And I sat in at an OTR, we were represented by counsel. I was supposed to be there to watch. And the examiner kept talking about what happened at Citigroup. And the reality is it didn't happen at Citigroup. It happened at Smith Barney. I'm sorry, it happened at Morgan Stanley. And I was representing actually both at the time. And I kept kind of kicking counsel under the table that you've got to fix that, because what's going to happen is it's going to wind up on the record that if there is some type of finding or some type of sanction, it can't be against the shop where it didn't happen. And finally, I said, I'm sorry to interrupt, but you got to be clear. You can't ask what happened at Citigroup. It didn't happen there. It happened at Morgan Stanley, and we're happy to answer those questions. And the person looked at me and said, I don't care what you call yourself. Okay, that's a room where things aren't going to go particularly well. And as much as I don't want to get yelled at, you have to make sure your record is clear. So a little bit of life experience, make sure your record's clear, and make sure you're trying to help out.
And then,
And with regard to,
oh,
I'm sorry, go ahead, Sean.
you know, witnesses needing breaks, right? I think you've got to be, it goes back to prepping them beforehand and realizing how long somebody can turn around and answer questions for. Some people can answer questions for an hour and a half and not have a problem. And somebody else, you know, every 45 minutes, they might need to get up and stretch their legs, and you need to know who you're representing and make that clear. And make sure your witnesses get breaks, because otherwise they can, you know, become forgetful, they get weary, and, you know, they're not being dishonest, but, you know, when you're tired and not on top of things, you might start making mistakes, and that just leads to hurdles down the road in terms of clarifications and whatnot. So I think you need to be very mindful of that.
100%, Sean. And before we go to the next slide, which we need to do because we only have 10 minutes left, I just want to briefly touch on witness closing statements, whether the panel thinks it's a good idea to have your witness make a closing statement. If they make one, should it be a blank, should it be a prepared statement? Should it be a Q&A? What is everyone's thoughts on that?
No, that's my thought.
That's it? Just no?
Yeah,
Anyone
No,
else?
the answer is no.
I'm in agreement there with Joe as well. I don't, and oftentimes witnesses want to make that closing statement. And I think that you're much better off getting your transcript and then explaining to your witness how, after the fact, we can turn around and make a crafty closing statement where there's going to be less likely for that examiner to start asking you more questions, because they start making that statement and you're in the room for another hour or so.
Yeah, I think that's generally true. I think the exception would be every once in a while, if there's something that can be easily corrected with a quick QA,
Right.
then that might be an opportunity to do it.
Like
But
a
otherwise, I would
redirect.
tend to agree. Yes, like a quick redirect. Otherwise, I
Yeah.
agree with you guys. Yes.
I used to love the arbitrators who would say, all right, the evidence is closed. Does anybody have anything they want to say? And I would have to kick people to remind them that, no, you only talk when I ask you questions.
Exactly. Okay, well, let's move on to the next slide, which is the process post OTR. So what happens after the on the record? What are the various scenarios? And so the first one, obviously, is the most advantageous one for the client, which is a no action. And I will point out that, of course, FINRA, after they issue the 8210 and get their documents, they can also give a no action letter. That happens a lot, that you get a no action letter without even going to the OTR. So I should mention that. But if that scenario doesn't happen and you go to the OTR, what are the different things that can happen? Well, we can have informal actions. We can have no action, get a no action letter. Yay. We can have informal actions by FINRA, such as, you know, they find a minor violation and you get a letter of caution. That would not go on a rep's record. What you don't want to happen is that they find a violation. If they find a violation, generally speaking, you get a phone call from the regulator, kind of a Wells call, and they talk to you about what their findings are. They explain it to you, and then they will provide you with an offer of settlement. We'll give you this, you know, we'll offer your firm, your client, your rep, you know, 6 months suspension and a $10,000 fine in response. And so here you need to negotiate the settlement. And the best way to do that is twofold. One, you want to look at the FINRA has disciplinary guidelines. And actually the language in the guidelines, which is available online, actually says the purpose of it is for FINRA staff and respondents to, I think the language actually says, to craft a settlement. Right. So you want to look at the guidelines, and they provide you with general principles and guidelines specific to different violations, suitability, churning, et cetera. And what you want to do is you want to speak to the regulator about the mitigating factors, that there's aggravating, there's mitigating factors. And you want to highlight the mitigating factors in your case that show why the sanction that they're offering is too high. And the mitigating factors could be, for example, the individual has no other, nothing else on their CRD. It could be that they, you know, if it was an individual, they admitted the wrongdoing to the employer, or if it's the firm, they admitted it up front to the regulator. It could be, you want to point out if it's an isolated incident. as opposed to a pattern of misconduct. These are all mitigating factors that you want to point out. So definitely you must look at the guidelines. And the other thing you want to do is you want to, another thing is big thing is intent. Going back to have to point out something criminal. You have to look at the intent. Was it a reckless act? Was it an intentional act? Were they stealing money? Or was it just a negligent act, like an unsuitability claim? So that's very important with regard to the type of settlement offer you're going to get. The next thing you want to look at is other disciplinary records offered also online and publicly available, because also in the guidelines they point out that the goal, FINRA's goal, is consistency. They want to give the most consistent outcomes. So you want to look at the guidelines and you want to find that's the best way to do that. And then just quickly, so you want to look at the guidelines and you want to look at the other awards and look at comparable sanctions for the same conduct. And then once you come to an agreement about your settlement, you want to, and you get the written AWC or offer of settlement, you want to negotiate the language in that AWC. You can't change necessarily, generally speaking, the findings that FINRA has, but what you can do is you can try to soften the language. You can make sure the time period is being properly explained. You can make sure the language is not too broad. Recently, I had FINRA take away a per se unsuitability finding to just say it was unsuitable for the individual as opposed to per se unsuitable. So you want to soften the language and you want to make sure that the language as it appears in the AWC is as advantageous for your client as possible. And then before we go on to, I know we're running out of time, I just want to point out, if you can't come to some kind of agreement with the regulator on a settlement, I think it's important, they are guided by their supervisor and their hands are tied at a certain point. And if you really believe that your client should get a better deal, there's no harm in asking them, hey, listen, I understand your hands are tied. Can I speak to your supervisor and discuss this? You may want to speak to them. You may want to even go the extra step and do like a PowerPoint showing why it is that it's unreasonable. Because going back to the word reasonable, FINRA staff is reasonable. Generally speaking, it can be reasonable. And if you give them a reason, they will work with you. So I kind of rushed through that, but we have to move on to our next slide, which is the actual disciplinary hearing. So you're unable to settle. On when should you not settle, and when should you go to hearing, and what are the best practices at the hearing? And I think Sean is going to touch on that topic.
Right. I mean, in what, the 3 minutes we have left here.
I know. Sorry, I talked too much.
That's okay. I think first off, though, you need to make sure your clients understand who's going to be the trier of fact. That you've got a hearing officer, somebody who works for FINRA on the panel, and 2 industry panelists. I think all of us have been industry panelists in disciplinary proceedings before. I think you need to make sure that your client understands that prevailing is not going to be necessarily as simple as they think it is. And then I think when you're there, you're going to continue to be a zealous advocate on the part of your client. But there's a difference between being an advocate in an enforcement hearing or a disciplinary hearing than being an advocate in a arbitration. Although as a defense attorney, I don't think the difference is that much. You've always got to make sure that you understand that your credibility is important to your client, that you cannot promise to deliver anything that you cannot actually deliver, and that you've got to make sure the reasons for your defenses are really grounded both on the facts that exist in the case and the law, and that there's going to be a way for you to prove to this panel that's adverse to you to begin with that the enforcement proceeding that occurred beforehand is not accurate. And there, I think you've got to go through and mine through everything and make your case as simple as possible. Because if your case is relying upon a bunch of nuances, it's going to be very unlikely that you're going to prevail. But if you can ground your case and keep focused on what the key issues are, you're going to improve your likelihood of prevailing.
Just as a point of interest, I did look it up, the stats from January 2021 to date. There have been 320 AWCs and only 17 decisions through hearings. So it seems pretty clear that most people opt to try to settle the matter as opposed to proceeding to the full-blown hearing. So if we go on to the next slide.
And you might want to give the next code.
Oh, that's right. Move on to the next slide. We're just going to briefly talk about the appeal. So right, the next part of the code is staff. So the first one was FINRA, second part is staff.
And Angela, just to note, to those of you who've asked us questions in the Q&A, if we haven't answered them this afternoon, we'll get back to you in writing between today and tomorrow. So we're not ignoring you. We're just trying to catch up as much as we can, but I see some others in there. One of us will definitely email you back.
The second code.
I see some people. I see some people want the code. It's staff.
STAFF. FINRA
It's staff.
staff.
Yeah.
You're welcome.
All right, the
I said
appeal,
thank
we
you.
got 30
I said
seconds
you're
left.
Oh,
No, go ahead, Sean. Are you discussing the appeal?
Yeah, so basically your first order is to the National Adjudicator Committee. The second, you appeal to the SEC, and then finally it would go to the District Court of Appeals for DC. And that's, either side can appeal, and that's something you got to be mindful of. Let's say you prevail, at a hearing when you're representing a defendant. This isn't criminal court, and the prosecutors can turn around and appeal as well.
And just, by way of summary, I think that this is stuff you should be talking to your client about, especially if it's an individual.
Yeah.
Whether it's, whether you just AWC stage or whether you're going to proceed to hearing, they need to understand when they settle that they're giving up their right to appeal. And they need to understand fully like what the language of the AWC is going to be, and they have to understand everything, what the sanction is, what they can do if they are suspended. Just communication is key. So, with that, I believe we are out of time. And as Joe said, we will be responding to those of you who asked questions that we weren't able to answer at some point today. And we appreciate everyone joining us today. We hope that this was an informative and an entertaining presentation. And we thank you for joining us.
Thanks. Bye.
have a good day. Thanks.